Almighty Allah, the most merciful. Let's discuss the conversion of a private company into a public company into a private limited company. Ms. Yusra, please share this content with the participants.
Conversion of public company into private company, Section 46 of the Companies Act 2017 defines conversion of public company into private company in the following term. The following is the procedure to convert a public into private company. A special resolution shall be passed to amend the memorandum and articles to include all the provision relating to a private company. An application for conversion shall be filed with the Commission for approval. In case of conversion of a listed company into private company, the Commission shall give notice of application of conversion to the Security Exchange.
Thank you very much. Let's pause here for a minute. You see, since this conversion can affect the public at large, especially if it is the conversion of a company which is having investment by the public, then of course this notice to the Security and Exchange Commission is a legal requirement. Moreover, this conversion is, in fact, it is a mandatory requirement that this must be, the conversion request must be based on a special resolution. And of course, at the time of conversion, because you are going to change the complexion of your company, so for that sake, articles of association and memorandum of association are required to be amended. And that amendment, in fact, amended documents will be required once you intend to seek a conversion. Next point, yes, Ms. Asma, can you read point number 4 for the?
Yes, sir. If the Commission is satisfied, it shall allow such conversion by an order in writing. A copy of the order confirming the conversion shall be forwarded to the company and registrar within 7 days.
Thank you. Thank you very much, Ms. Asma. Thank you. Now, you see, this is important that Commission will make itself satisfied. The primary purpose of this is that Commission will look into this fact that whether this conversion is not motivated with some ulterior motives, or the purpose of this conversion is not to defraud its creditors. The purpose of this conversion is not to, deprive the legitimate owners of the company from some lawful rights. So on all these points, the Commission, the Securities and Exchange Commission, will satisfy itself. And after, once it is absolutely satisfied that there is no bad intention, there is no mens rea involved, there aren't any ulterior motives, or there aren't any mala fides involved, after ensuring that this conversion is for the sake of good, then Commission will permit that, will allow that conversion, and that permission will be in writing. Secondly, this is discussed here, keeping in view Section 46 of Companies Act 2017, that this confirmation actually will be forwarded within a given stipulated period of time to the concerned company, so that they can incorporate that for their. Next 2 points, let me have Mr. Fakhr read for the participants.
Yes, sir. A copy of altered memorandum and articles shall be filed with the registrar within 15 days of the date from the date of order. The registrar, upon registration of the memorandum and articles, shall issue a certificate to this effect.
Right. So once this order is passed, that yes, the Commission is satisfied, the registrar is satisfied, and he has permitted the alteration, then of course within a period of 15 days, the altered memorandum of association and articles of association. Let's take the last point of our Section 46 of Companies Act, and that point is that the conversion of status of a company shall not affect any debts, liabilities, obligations, etc. So as I said earlier, that this conversion should not be for gaining undue benefit. The conversion should not be to defraud its creditors. And moreover, law keeping in view this possibility that people may move an application that to seek a conversion in order to defraud its creditors, or in order to, in order to avoid fulfillment of their liabilities and obligations. So for that sake, this is incorporated here, that the conversion or the status, the change of status will not affect in terms of debts, liabilities, and obligations, which are otherwise accrued to the company to be performed or to be fulfilled or to be undertaken. So let's conclude on this point, that the conversion from a public company into a private company, the steps are being discussed in section 46. So with these words, let's conclude this point. Thank you very much for your participation. In the name of Almighty Allah, the most merciful, let's have Mr. Yahya to share with us this content for the conversion of a private company into a public company. Mr. Yahya Ijaz, please. Conversion of a private company into public company.
Okay.
Let's start that there are following two ways to which a private company may become a public company. So let's, two ways are being discussed. So the first way is by choice. Yes, Mr. Yahya.
Conversion by choice. Section 46 of a Companies Act 2017 defines conversion by choice in the following terms. The following is the procedure for conversion by choice. A private company shall pass a special resolution or exclude the provision from its article which are required for a private company. On the date of the alteration of articles, it shall become a public company. It shall file with the register a copy of the memorandum and the article as altered along with the special resolution.
Thank you very much. Let's pause here, Mr. Ijaz, for a minute. So this conversion from a private limited company into a public company is being discussed. And if a company which is otherwise working as a private company, and now it is entrusted to change its status or nomenclature, and then of course, and that is by choice. Then of course, these are the steps which are discussed. And of course, for that reason, special resolution would be passed and altered articles of association and memorandum of association are required to be submitted. Let's take the next point, and that is point number 4 and 5. I have just highlighted in red for you.
Yes, sir.
Let me have Ms. Mahanur to do the reading for the.
The registrar upon registration of the memorandum and article shall issue a certificate to that effect. The conversion of status of a company shall not affect any debts, liabilities, obligations, etc.
Absolutely right. So even if a company is entrusted to make this conversion by choice, that conversion will not affect any debts liable to be paid by the company, any liabilities, or any obligation required to be undertaken by the company. So if you are a private limited company and you have certain obligations to perform, or you have certain debts to pay, or you have certain liabilities to undertake, your status or change of status or conversion of status will not affect that. Thank you very much, Ms. Mahnur. And now the second aspect of conversion. We said that there are two possible ways of converting a private company into a public company. One is by choice, and that is discussed in section 46 of 2017. And second possibility is by default. Now, section 52 of the Companies Act defines conversion by default in the following terms. Let me highlight the portion for you to be read. And let me invite another participant of our class to share with the remaining participant. Let me ask Mr. Abdul Rahman. Rahman, please.
Yes, sir. Where a private company makes defaults in compliance with the statutory requirements of private company, that is membership exceeds 50, permits free transferability of shares, or open invites public to subscribe its shares to debentures, the company shall automatically become a public company. The commission may grant relief on such terms and condition as it may think just an expedient. expedient. The application may be made by the company or any interested person.
Thank you very much. So you see, we know that private company is one who can have a membership of maximum membership of 50% members, or there is a ceiling in terms of membership. Let's say that if that limit has exceeded, then by default, that company will be considered as converted into a public company from a private company, number one. Number two, we know that in private companies, their shares are not freely transferable. The directors of a private company, if they intend to transfer their share, they cannot do so freely the way they can do it in public companies. But if they have permitted that, then by default, we can say that now their status is changed. Now from private company, they are converted into a public company. Moreover, you know that private companies, they cannot subscribe their shares or debentures to the public. Debentures are a kind of secured form of shares. These are also kind of shares, but these are secured kind. We will discuss its definition later. But on this point, while discussing the relevant section of Companies Act, I just want to confine myself to this point, that if they have invited public, there is a private company, the private company has invited public to subscribe its shares, then that act will by default convert that company from private company into a public company. So these are certain aspects which were required to be discussed while looking at the conversion which can be made under section 50. I'd like to invite questions here. Yes, please.
No questions, sir.
Sir, if a company is being converted to public company, their liabilities transfer as well? The liability of the members change as well?
Well, as a matter of fact, as we discussed in section 46 of Companies Act, that this conversion from any category will not affect the debts, liabilities, and obligations, irrespective of the fact that previously the company was a private company, but now it is converted into a public company, or vis-a-vis.
So I'm talking about the liability of the members of those company, not the company itself.
Well, you see, the liabilities of a company, members of the company actually, will be based on the changes made in articles of association and memorandum of association. If the altered articles of association and memorandum of association says that members undertake a limited liability, or members undertake an unlimited liability, then according to that alteration, their duties and liabilities will be affected. Got my point?
Yes, sir.
This is why at the time of seeking an alteration, or at the time of seeking a conversion, actually, altered articles of association and memorandum of association are required to be submitted along with a special resolution seeking a conversion. Any other question, please?
No, sir.
So that's brilliant. So with these words, let's conclude this topic. Thank you for your participation.